Good morning, good afternoon, good evening, folks. Michael Zuber, one rental at a time, back with the one and only and true gentleman giving back to the one rental at a time community, Rylis Dana. How you doing, sir?
Amazing. Always love being here with the ORATers, the one rental at a time community, and the crazy individuals like myself, huh? People who love this stuff. Spending a Saturday nerding out, learning some skills to make your life better and your family's life better. So glad to be here.
Absolutely. So, folks, what we're going to do, remember these days, these deep dives are for you. You probably come with questions about probate, what it is, how to do it, what are the vocabulary, maybe how to work with probate attorneys. All questions are open. Please, please, please start putting your questions in the chat box now. What Rylis and I are going to do is go through a quick PowerPoint kind of covering what we thought the basics would be, and then we will go to your questions. We will likely get through all of them if this is just like all of our other sessions. So, Rylis, I'm going to turn it over to you. Remind people the states you're licensed in, where you help, your experience, and then let's get into the PowerPoint.
Okay, so yeah, can I go ahead and share my screen?
It's all yours.
All right, so there we go. So my name is Rylis Dana. I practice law in Arizona and California, probate and estate planning. That's my day job. And then like this community here, I'm also a real estate investor. So I'm interested in real estate investing, and my day job sees me transacting in real estate a lot too, and solving real estate problems. So today, as Mike said, the topic is probate. We're going to start off with going through some of the basic terms. So this is going to help everyone in a few different levels. So one, we're all going to die, right? Mortality rate still 100% last time I checked. So this is relevant information for everyone. You know, you're going to have parents, loved ones, friends, things like that. So it's going to help to understand this. So first of all, we're going to talk to this basic level. Then we're going to talk about what it should look like, what your estate plan should look like as a real estate investor. And then we're going to talk about ways to develop strategic relationships with probate attorneys like myself. Then I'll talk about how I've made relationships with different people in the real estate community. So there's a lot of terms that they get kind of used interchangeably. And I'm always correcting people because it can be important, or it's how you use these terms. So decedent is the first one we'll get into. It's basically the dead person. Decedent's a nice way to say dead person, or the lawyer way. So,
the lawyer way of, yeah, okay, got it.
Right, like that lawyer way. And then fiduciary is the next basic principle. So that's who's going to be in charge of managing the money. Their general role, I call them a fiduciary, and I use this green bookkeeper visor. So for those listening on YouTube, I know I listen to a lot of your content, Mike, when I'm doing other things. This is going to be one to look. We got a lot of visual cues. So if you can look at your screen, it's going to be helpful. Yep. Beneficiary is the other major player, right? Who's going to get the stuff? So who died? Who's going to be in charge, and who receives from, whether it's a trust or a estate. There could be multiple beneficiaries as well. So next term, let's talk about estate. Is it a large house? Sometimes people say that, but in my world, estate planning, I'm not planning for large houses necessarily. Well, we are kind of in a way, but we refer to estate as everything a person owns, whether alive or dead. So that's the ghost of my friend Mr. Estate there. So alive or dead is someone's estate, right? Oh, so everything in a person's name, whether alive or dead, is there.
Actually, Rylis, can you go back? There you go. The one thing I want to point out here, and again, tie our deep dive sessions together. So we've done a deep dive on seller financing. One thing that's represented on this slide is obviously the home or the property can be a part of someone's estate. But something else that could be part of the estate would be a seller financed note, right? If they sold this house and this house is off the screen, it could be replaced with a note, right? That note is part of their estate. So it doesn't just disappear. Like if this guy dies and ghosts, you don't have to stop paying. No, you owe somebody that next month's payment, and it's likely controlled by their estate or is in their estate.
Yes, yes. So when you sell and you hold a note, that's an asset. So correct, it is part of their estate. All right, fiduciary. So that green visor person. So fiduciary, here's the definition. It's a person to whom property or power is entrusted for the benefit of another. So whenever they're wearing that visor, they have a fiduciary duty, which is a legal obligation of one party to act in the best interest of another.
Mm-hmm.
So these are the basic principles that it all boils down to.
Can you go back? Oh, sorry, go back. So let's poke at that legal obligation, right? So when you're setting up your estate, which all of us should, you got to think about the person you're entrusting, right? They have a fiduciary duty. What could happen if somebody doesn't behold that? They take everything themselves, their siblings get involved, and is there legal ramifications?
Yes, yeah, they could be personally liable for their actions.
Exactly. Yeah.
So that includes self-dealing,
Yeah.
right? So if they're one of the beneficiaries as well as the fiduciary, so if you have one sibling who's in charge, but also a beneficiary, they can't end up with a larger share or something that's better than what their siblings receive.
Exactly. There's liability there.
Yeah.
Okay.
Another thing too, like you can name companies to serve in that role. And people will often ask me, they say, how can I trust this company? A lot of time I have a lot of clients where they don't have a lot of family members that either live in the country or they just don't have any family members or close friends that they would trust in that position. Mm-hmm. But if a company serves in that role, they have a legal obligation to do what's in that person's best interest. All right, so let's look at a last will and testament next. So last will and testament is a document. The person that makes it, it's called a testator. That's what the last will and testament. So you name beneficiaries, where things are going to go. If there's minor children, they get named, and you name who's going to be in charge. So a last will and testament does not do anything until the person dies, right? Because as long as they're alive, they're controlling everything. But when they're gone, the last will and testament controls the assets that their ghost still has. Kind of going back to the other slide. So if things are still in the name of the deceased and they have a last will and testament, that's going to be your instructions. That's going to tell you where it goes and who's going to be in charge. But to activate those things, you need a probate or something through the court. And this is going to vary a little bit in every state, but to activate a will, there is something through the court that's going to need to be done to appoint those personal representatives and guardians. All right, what if there's no will? This is a question I get a lot from investors. I love this one. So everyone, listen closely here. So many times I've been tagged, or we even get calls like, this person died, they have no family. Like, can I just have the house? They don't say exactly that, but it's like, there was no one and I was their best friend.
Yeah,
but
it's mine, right? Yeah.
Yeah. So if there's no will, it's called intestate. Just a fancy word, means no will. So what you do, there's state laws. So if the person died in California or Arizona, you look up the laws in that state and you see who it says the beneficiaries are. So the state laws are going to tell you who the beneficiaries are and who has priority to serve as a personal representative. It goes all the way out to like second cousins.
Wow.
So if people say, well, there's no family, it's like, really? Have you looked all the way? Have you hired investigators to see if you can find a second cousin? And if there truly is no family members, then it goes to the state. It doesn't matter that you painted their toenails every Sunday morning. how good a friend you are. You're not, if there's no legal relationship,
Mhm.
either a marriage or a child or relationship that way, then it's going to go back to the state.
Okay.
So if there's no will, you need to, you got to do a little research to figure out the family situation. So probate, judicial process, this is kind of like the words of it.
Mhm.
There's different types of probates. That's where this can be confusing. It varies in every state as well, too. So it's really important that you get specific advice to your state. So be careful if you have a friend telling you how to do it and they're talking about their experience from another state. So this, I won't go all the way through these, but in Arizona, we do informal probates, which basically means we don't have to go into court and have hearings. In California, they're all what I would call formal probates, meaning there has to be a court appearance to open up the probate, and there's a court appearance at the end to close the probate.
Yeah, this is why, again, I'm a California investor. When you get probate deals or leads, it's not fast. There is a process and formality, and obviously the pandemic just extended that entire process longer and longer.
Yeah, so it's important to understand this process to know the timing of it. If you're looking at purchasing a house from the estate, or if there's a deceased person on title. So this is going to be a big difference whether it's informal or formal. In a formal situation, again, there's different levels of that too, but sometimes they may need court approval for the sale of the property. So that can be really tough for real estate investors because they want, a lot of times the judges, what I'm hearing, again, most of my friends are in Southern California, and they're saying that they like to see retail sales. So in California, the properties get appraised by what's called a probate referee.
Yep.
And so that gives the court the value of the property. So if it's
Yeah,
if
and
price,
I want to poke at that a little bit, Rylas. I've done a probate deal. The other thing that's about this probate referee is I understand it. Please correct me if I'm wrong. Their job is to evaluate the property value at the date of death, right? Because one of the probate deals I did, or go ahead, you can answer, I guess.
yeah, data death values is what they're looking at.
Yeah, and that's important because the deal that I did, the person had died like 3 years prior, right? It just took this long to get there. And basically where we were at is we didn't know where the value would come in. It came in just under what we agreed to buy it for. So the transaction went through. However, if that value would have come in over what we had agreed to buy, there's a chance it would not have gone through. So just FYI.
Correct. That's what I'm hearing as well. So since they have to have a hearing, and the California probates can drag on like forever because any little thing at those hearings, the judge will say, no, I don't like this, come back again.
Yeah, this one was over 3 years.
Yeah. When every time it's, a lot of times 3 or 4 months out every single court hearing. So they don't like something, another 4 months, and then maybe they bring up something else they don't like then. Okay, so how long is probate? So again, this is my graphic to probate is appointing that personal representative. Here's kind of our Arizona timelines. So once someone hires us in Arizona, we're about 2 to 3 weeks to prepare that initial application. Sometimes that's like, 3 to 5 weeks, just depending on our workload. And then after and also this first part, when you hire an attorney, they're going to need a lot of information from the family members as well. So meaning all the addresses of the children and beneficiaries and things like that. So that can really slow things down. So later we're going to talk about how to develop a relationship as an investor, but you want to be a good client. I'm going to give away the end. You want to bring value. So if you can help the attorneys in this stage and do the legwork, get all the addresses of the beneficiaries and have all the information ready, it's going to speed up this process. Other times sometimes it drags on months just for us to file the application because we don't have, a sister's address who we need to include in our filings and send her notice of everything. All right, well, then once everything gets filed, we're about 2 to 6 weeks. This is an informal probate process. So about 2 to 6 weeks, most of the Arizona counties is what we're seeing for them to approve the documents. Now, once that happens, that's when the sale can actually be done. As soon as the court grants the authority, at least in Arizona, and maybe in California, depending on the level of the probate, you still might have to get permission. But once a person is appointed, so the probate's still going to be open for a while, but they can change the nature of the assets from house to cash.
Right.
It may be a while before they can actually distribute that cash out, but at least that sale can go through generally right after the personal representative gets appointed.
Okay.
So for investors, I feel like that's the first important timeline, right? It's like how long is it going to take before someone has the authority to actually sell the house? And then after that, there's going to be several steps that need to be done. Again, it's going to vary state to state. Arizona, we got a 4-month creditor period, same in California, where you have to notify. So you publish to give any unknown creditors a chance to make a claim. If there's creditors that you know about, you have to give them notice of the probate. And then during that time, you can collect the assets, like sell the house, sell the real estate, determine what creditors are valid, send an accounting, and then after the time's run up, so if the 4-month creditor period is over and you've gone through all those steps, then you can make a final distribution. So that's the process that you're looking at for a probate. Arizona, I would say probably about 9 to 12 months is their average. Some can drag on, for various reasons. We have some that are, 2-3 years old that are dragging on for various reasons. All right, so this is the process that I go through when evaluating estates. So if you're meeting with someone, this is the process to go through. So first, I take a look at what the assets are. What do they own? And in our world, we're probably looking at real estate, right? There's probably some sort of real estate if you guys are involved as investors. So you want to define the players, figure out, who died, who's going to be in charge, and who the beneficiaries are. And then what controls the assets. So IRAs and life insurance, they commonly have beneficiary designations. So you look on those contracts and see who it names as a beneficiary. That you look at the title for the house. So if it's in the name of the dead person, it's in their estate. Or it could be in a trust is the other choice. The title might be owned in a trust. Bank accounts may have a beneficiary, or they could be in a trust. So if things are in the name of the ghost, the decedent, if they have a will, that's going to be controlling. Right. If they don't have a will, then you look at the laws of intestacy. Got it. If it's in a trust, then you look at the trust. So that's why I use the terms fiduciary, right? The fiduciary is who's in charge, but it might be under a trust, a will, or just the laws of intestacy. All right. So anything else on that, Mike, as we wrap up? That's kind of our basics. And then now.
No, go ahead. You're on.
Okay, keep rolling. So this is what an estate plan should look like for investors. So revocable trusts, especially in states like California, Arizona, where probate's a pain. I think some Midwest states, probate's not a big deal. So maybe people aren't as worried about avoiding probate. But where I practice, I like to avoid probate. So a trust is a document. You designate where things will go, when and how they'll get there, and who's going to be in charge after you're gone. And I'm not going to get too deep into that today because I want to get through all these topics. In Arizona, when you take title in the name of a trust, you have to disclose who the beneficiary is on the deed. Okay. So sometimes people are wanting to remain anonymous, but with the regular revocable trust, you have to disclose who the beneficiary is. I'm a fan of LLCs. again, we're not going to get too deep on this today, but if there's an injury in one property, potentially all your assets are at risk, versus LLC, if the liability took place in the property owned by that LLC, it would limit the liability to just that one property. So that's why I'm a fan of LLCs. You can go to the playlist on the channel. There's lots of conversations about that. But this is how investors can keep their name off the record in Arizona. So if you do a regular LLC, you have to disclose the name and address of the members. So it's really easy to go look up LLCs and figure out who the owner is. So what I like to do for my real estate investor clients who want to remain anonymous, we'll do what I call a privacy trust. And this is a trust where basically it stacks on top of your regular revocable trust. So the privacy trust doesn't have your name included as part of the name. And the beneficiary of this trust is actually your revocable trust. So it dumps into your regular estate plan. But the purpose of this is to use it together with the address service of another company in order to form LLCs that have your name off the record. So if you create an LLC and the owner was this stealth name trust, the address is your attorney or some statutory agent, your name is not on the record at all.
Yeah, just so I think you've said it, but just to make sure, this is very Arizona specific. This was not apply in California, for example.
This would work in California too. Everything is very state specific though, which is a good point. So everything you want to talk to someone in your state. But same idea in California. So California, if you have an LLC, you have to disclose, who the members are, and you have to have, they call it a statutory agent, meaning who they're going to deliver service of process to if you get sued.
Got it.
So you got to have someone's address to use for that. So this general idea works. And this also works. Like I had a client the other day, he has a Wisconsin privacy trust, not Wisconsin, Wyoming privacy trust. I know a lot of real estate investors do stuff in Wyoming. So we used his Wyoming LLC this way. So he owns Wyoming LLC, is where he's going to own his other LLCs. And then the beneficiary of that LLC is his estate plan.
Got it. Okay.
So estate planning for business interests. So if you own businesses, which as investors and entrepreneurs, we tend to collect entities and LLCs. So they should all be owned by your trust. Big picture. So you want everything as part of your revocable trust, so it avoids probate, passes on to your family. And then if you want to get, some more protection by keeping your name off the record, you could have a privacy trust or some other entity to hold things kind of off the record. All right. Anything on that topic, and then we'll go into
this is why I don't talk LLCs and trusts, right? I don't pretend to be a CPA or an attorney, because everybody's situation is different. Everybody's plan is different. What might work for me doesn't work for you. So, when people sometimes get frustrated that I won't answer, LLC questions, it's like, I'm not going there. I don't know your situation. Go talk to an attorney. This is why I don't answer questions, because there's so many options.
Yeah. And I punt a lot too, is what I'll say. I say, talk to your tax guy. But big picture, I want to avoid probate. This is real general here, right? I want things as part of the estate.
Now let's talk about that. Why do you want to? Why is avoiding probate a good idea? Why do people do the legwork to avoid probate? Is it time, cost, taxes? Just let's talk about why you want to put all this energy here early before you're a ghost, to prevent probate in the future. Time,
absolutely time. We're all smart people here watching this. We know money now versus money later. Who cares? Let them pay the money. But it's time. Your loved ones are going to be cursing you You know,
Yeah.
like, why did they do this to me? You know, I have it all the time, like the frustration right after the loss, right? As you stack those things together,
Yeah.
what may seem like a relatively simple task, probably for this audience, right? And transferring assets and doing things like that, it's a lot harder when you just suffer the loss.
Sure. Okay.
So
Perfect.
time, it's a great gift for your loved ones.
Yeah.
And I'd say second is money, meaning it does, you are going to probably want to pay professionals to help you. And then if there's not clear instructions, a lot of your money could be lost just with them fighting over it.
Yep.
Or just having to collect it. I've had people where they've left assets in multiple states. So we end up doing probates all over. So it's yeah,
it's
not
not
a pleasant
free.
experience. No.
It's not free. Yeah.
Yeah.
Okay.
Okay, so last topic for our before we open up to Q&A and see what questions we have. So when developing a relationship for attorneys, what are you bringing them? And again, I'm a little biased on this side, but this is how I develop relationships too. I practice this. When I want to get to know someone or when I want to develop a relationship, I have to show them that I have something of value for them. So meaning when I've wanted to meet other professionals, I follow the same thing that I'm going to tell you is, and I brought them a client. I said, I have this type of client. Can you help me do this right now? Like I have this situation and I want your help.
Yep.
So now I get stuff every day. My team leaves them for me because they know I'm just I'm an investor, and they know sometimes I'll show them on things like this. But I get probably 2 to 3 things a week.
Sure.
In the mail, and then I know LinkedIn, I get just bombarded every day. I don't even open it up. I get like, you know, all these people, you know, wanting to tell me how great they are.
Yeah. Yeah. I want to help you. Yeah. Help me help. Yeah. I get it. Bring value. Yep.
So this is my guaranteed way, guaranteed. This always works. And tell me if you agree, Mike. So to make a relationship with an attorney, go through the front door with what they're looking for. Bring them a client, the type of clients that they want. They're going to talk to you. So, but you want to be clear about this, and you want to actually, you know, you'll have a client. So, probate, trust administration. So there's a lot of people watching this. You're out there doing the legwork. I feel like that's part of the reason why I love this community is they've brought me lots of legal work. You know, when I have friends that are real estate investors that are knocking on doors and cold calling, they're discovering situations where there's someone dead on title and they need probate and trust administration. So the other thing you can do is if you haven't found anyone that needs a probate or trust administration, a good way to get to know them is to hire them to do your own estate plan. So find someone in your state, your city, that you want to develop a relationship. And this is a good way to do it. Good way to get to know them, you know, see how they work and to start a relationship. I'd say all the relationships that I have that I've done a real estate business with and that I've just made real estate referrals with have started this way. You know, I get bombarded by things in the mail every day, but I'm remembering the people who bring me clients who come hire me to do their legal work. So they're going to be on the top of my list. It's just how it goes. The last step on here is be informed. So you want to be a good client. My paralegal, I'm pointing, it's Saturday, but she'd be across in her office the other days. if you make her life easy, she's going to love you. If you're a
Mhm.
pain in the ass and she's got to explain the same thing to 5 different people on your team, she's not going to love you. And if I recommend sending deals to your company, she's going to be like, no, like, are you kidding me? Like, do you know what I have to go through when we work with them? So, this last part, I want to help you be more informed. So when you contact attorneys, so hopefully this groundwork that we did will help you with this last step. So I have a checklist here. There'll be a link at the end where you can get this checklist in a Google Doc. But this is what I want you to go through whenever you see, when you see someone dead on title. So if there's real estate and there's a deceased person, this is what you'll do. And again, so start with who's going to sign your contract. I've had people tell me about what their assignment fee is going to be, this and that, how good of a deal it is, but there's no one that can sign their contract, right? It's a situation where there's no family members. You know, they haven't done the research to see who would have the authority, and the foreclosure auction is next week.
Right.
Like, sorry, buddy. Like, you spent too much time calculating that commission, and you should have done more work, you know, figuring out if there's anyone that can sign your deal.
Yep.
So who you're speaking with, who's your contact? How is the property title? If there's not a match there, that's the first question, right? So that's, if there's someone different that you're talking to than what the title says, then you need to start asking questions. So if there's multiple people on the title, you'll want to see how their interest passes. Does it say rights of survivorship or tenants in common? So that would mean their share of, rights of survivorship means their share passes to the other people on title.
Mm-hmm.
If it doesn't clearly say those words, then it's going to go to their estate. If it doesn't clearly say rights of survivorship and one of the owners is dead on title, their share goes down to their estate. So again, we go back, if it's in the estate, we got to look to see if they had a will. If there's a will, that's going to tell us what's going on. If there's no will, then what you need to do is figure out the family situation. Were they married? Did they have kids? Were the kids common to the relationship?
Mm-hmm.
So that's going to determine who has priority to serve as a personal representative. And you don't have to know. I don't expect attorney or investors to know who's going to have priority to serve, but if they can get an idea of the family dynamic and call an attorney.
Yeah.
This person died. They did not have a will. They were married. They had, these kids. It's going to be helpful if you look up the laws of intestate succession to get an idea if you're talking to the right person. But again, if you have a good idea what the family members are and you call an attorney, then they can point you in the right direction and help you out. But this crowd here, I feel like this crowd likes the information, right? They'll look it up and they're going to want to read the statute, and they're not going to want to wait to go see an attorney. Now, there could be several people that have equal priority to serve. Like if they had 5 kids, all 5 of those kids are going to be the beneficiaries, and all 5 kids have equal priority to serve. All right. Once you know that information, then the attorney can help you, or we want to know a little bit of financial information. So I like the tax assessed value. I feel like is helpful. In Arizona, that's the value that they use. California, we talked about how they do the probate referee, but I still think looking at the tax assessed value gives some sort of starting point. And is there any mortgage or debt on the property? And when did the person pass away?
Yep.
So there are alternatives to probate. I think that's one of our questions that we'll get to in the side. In Arizona, the way it works is if you wait 6 months after the date of death and the value is less than 100,000. So that's the value in the tax assessed year that you're filing the affidavit minus any debt.
Okay. So that's the net value.
Yes. Now this affidavit needs to be signed by, so if there's a will, that's going to list the personal representative. If there's no will and 5 kids, it would take all 5 of those kids to sign it.
Oh, wow.
So sometimes that's a problem. Sometimes we can't get a hold of 1 or 2 of the kids. So you could open up a probate. You could give notice and then open up a probate and get the authority. But to do these affidavits, you're going to need everyone to sign it. Okay. All right. That's all the content. That's all the plan stuff.
Yeah, I think this is really good. Show them your giveaways, because again, you brought stuff for others. You have a great YouTube channel with a lot of this kind of nuts and bolts stuff that goes even deeper. So let's talk about that.
Yeah, so this is a link here. Oops. Well, I'll pause it, but it's this is a video. There it is. So my YouTube channel, Mott Legal, is where I share the most content. And then I have a link. Here's a link to a Google Doc, that checklist. So you can go here and download that checklist. Subscribe by Mott Legal, trying to get up to 1,000. And this is where I share the most content. If you have questions, there's a lot of videos in there where I go back and explain these things. And you can leave comments there, or leave comments in the Facebook group or other places. I'm happy to help out.
Yeah, what I would tell everybody to do here, there's probably lots of questions swimming around in your head. Instead of asking me, because I can't answer them, I would suggest subscribing to Mott Legal. Become a subscriber, bring him value. Let's get him to 1,000 subs. And then on his videos, put in comments. I know he interacts with his audience. So if you have deeper dive questions on this topic, you know, that we've painted here, show him some love. Go to Mott Legal and subscribe so we get him to 1,000. And I'm sure he'd be very appreciative of that. So Rylas, you ready for the chat?
Yes, yeah.
All
Let's
right.
do it.
Let me
Do you want to tee him up?
Yeah, I'll tee him up. I'm just trying to figure out how do I get to the chat box. Easy. I guess I'll do this. There we go. All right. So we'll just scroll to the top. We always start at the top. So Victor, good morning. How are you? Sakis, good morning. Chester, good morning. Trade Better, good morning. Charles, good morning. All right. So Vice. Is there a form in California that can be used in lieu of probate to sell a property less than 120K, only one heir?
Yes. So California has a real property affidavit process as well. However, you got to get that referee involved as well. So that's where the value comes from, but it is possible.
Is it the same limit at 100 grand?
California is 150. California is 150.
And that's net value. So this is where people got to really watch the vocabulary. Let's say the property is worth, let's say it's worth 200 grand in this example. You think it doesn't qualify, but it has a first mortgage of 100. We're talking net value, right, Rylas?
Yeah, I'd have to double check in California, but I believe that's my understanding.
Yeah, but either way, in this case, it's 120. You're under that limit of 150. And yeah.
Yeah. Now, in every county, the probate referees work a little bit differently. What I mean by that is sometimes they're assigned by the court once you open up a probate, or once you you have to ask the county for one. I think in other counties you can pick one off their list that are approved and kind of do it that way. Very
cool. So Chester asked, for probate sales, would it be better to work with an estate lawyer or an executor / administrator?
Depends. So I would say on each individual case, it's better to work with the executor. You know, they're really the decision maker. Now, as the attorney, I can make recommendations and try to influence and try to get them to go with someone I trust.
But the executor's been given the power, right? He or she is like, you're going to take care of my estate. I'm a ghost. Basically, you're in charge, right?
Yeah, and I'm going to use the term personal representative. That's what we use in Arizona and California, meaning the person named in the will or the person who gets authority over the estate.
Gotcha. Very cool.
Now, the attorney, though, the good thing about developing a relationship with the attorney is they're going to be going to bat for you in their client situations.
Mhm. Yep.
So both.
Both. Yeah. Yeah. I agree. Sir Sarkis, are probate cash purchases only?
Not necessarily. A lot of times they're sold on the MLS on
Yeah.
the retail market. So there's
Agreed.
buyers
Yeah.
can bring
Yeah.
can
They don't
get
care where their money comes from. They don't care if it's a bank or a person or yeah. Yeah. There will be there will have to be. Yeah. Yeah. A loan's okay. That a probate doesn't mean you can't have lenders.
correct. I would say all the same options are still available, whether the person's alive or dead on title. Just
Correct.
if the person's dead on title, we just have to go through some more work to get the authority.
So Kenny's asking, if you don't have an answer for this, I do. How could we get a list of properties that are in probate? I'm thinking of targeting probate sales to get a creative finance deal.
Yeah, so several ways. One, you could go to the court. I think it's probably the cheapest and easiest way. And depending on your county, you may be able to get it that way. And there's several places to buy data. I'll let Mike share those things.
Yeah, so this is one of the things that's become a lot easier over the last 5, maybe even 10 years. There's a company that and I've used PropStream. PropStream essentially is a big data lake collecting dozens and dozens of data sources, one of them being court documents, because there is a set of documents, I don't know the numbers, but basically talks about real estate that are in probate or part of someone's estate. So that's why PropStream and others, Deal Machine, I think is one, and there's probably others, but the one that I've used is PropStream. Basically pay a data source. There's check boxes. Is it perfect? No, by no means is it perfect, but it's better than what we have now.
Here's my perspective as a probate attorney.
Mhm.
So again, whenever I talk with the lead, someone that hasn't hired me yet, I'm usually asking if they have a realtor yet. And I'm
Yes.
cautioning them. I'm saying just wait to sign a contract. And at least explore cash offers and other things before you're under contract with someone. But usually they have someone. And then as soon as you file probate, they get bombarded. I tell them, turn off your phone. Like you're gonna get bombarded.
Yeah.
Like my phone, I have to have it set up where it only rings if I know the number.
Me
Because
too. Yeah.
because
Same
I
deal.
get, you're on a bunch of records, and I'm on just as a probate attorney, I'm on a lot of them. So some people will skip trace my info, and so I feel like the better leads is if you can find them before that. If you can
Yes.
find them before they've actually gone through probate, and you can be the one that helps them find a probate attorney.
Yeah, I think that's the real key is basically holding someone's hand through the entire process. That was the deal that I was a part of, is we helped a heir kind of go through the entire process. So yeah, I agree.
Yeah, so if you're tuning in late, go watch the first 30 minutes of this, and that's going to tell you how you can look really good with attorneys. If you come in with that experience and you're really helpful, doing all the legwork, you have beneficiaries' addresses, you're communicating, you're making the process super simple. Those attorneys are going to be sending you their other deals. They're going to be asking you to solve other problems too.
Yeah. So we have someone who's clearly done some research on this, so we have some vocabulary. This is Chester. What are the ways to avoid probate? The ones I remember are else assets held jointly in common in name or signed for things like a deed, payable upon death, transferable upon death, later to or for bank accounts. I'll stop there on the first part. Is that all?
Yeah, those all work. So probate's just when something's left in the name of the deceased. So there's lots of ways that you can transfer title, or you can have a joint owner. Those avoid probate.
Next, property state claims is, I have no idea, is sheet?
Escheat. Yeah, they say
Sheet.
if it goes back to the estate, they say it escheats to the estate.
Got it. All right. Well, lawyer talk.
Correct. Good word.
How, yeah, that's right. It's an SAT word. How would a family member later claim a sheet property like a house, bank accounts?
It takes a long time before it actually goes to the state, but then you can get unclaimed property.
So I just want to make sure. So basically, a ghost happens. They look for the heirs. They don't find anybody. It goes to the state, and then suddenly the long lost relative shows up. They go back. That's what we're referring to here.
Yeah.
Oh,
And
okay.
there's unclaimed properties. Sometimes you can go back and claim it there.
But again, it's a long process.
Yeah, it's a pain. I think we've had people do it, and then there's just more fees and things get tacked into there, and the longer it is.
Yeah. How would taxes on an estate property work with a house appreciating quickly, say like over the last couple of years? And if that's a CPA question, it's okay.
Yeah. So I guess I don't know what he's asking. How taxes work in
So
what way.
well, I think this again is a CPA question, in my opinion. Basically, I think he's talking about a stepped up basis, and that's not a legal question. That's an accounting question.
Yeah, so there is a step up of basis to the fair market value at the date of death.
Correct. Yeah.
Now, something interesting came up the other day. I was meeting with the new prospective client and their advisors from the bank. It was one of my friends who's a wealth advisor in the trust department, brought this person in. And now we're looking at a situation where the person died a while ago when the basis was higher.
Yeah, exactly.
So they're going to be able to capture it for losses.
Oh,
so
wow.
Going back to establish that basis. This was in stocks more in this scenario. But yeah, it's a fair market value at the date of death.
Exactly.
And then when you sell it later, it's possible.
Yeah, it could be a gain, could be a loss. Yep.
Yeah.
Yeah. Is if there is a trust, there is no probate question.
Maybe if the trust was properly funded.
I was hoping you were going to answer it that way, because yeah, you could have a trust that's not funded, folks. Yeah.
Yeah.
Setting up a trust is not the end of this. Yeah.
Yeah, there's a lot of what I call it as fancy binders. You know, people will do a trust, they're all proud of it,
but they don't fund it. Yes.
Yeah, and it's just a fancy binder. It doesn't avoid probate. Unless you get your assets inside of it and you have beneficiaries listed on everything.
Yeah. So funded meaning getting your assets into the trust. Yes.
Yeah.
Would a register of wills or probate magistrate have to give final approval for a house sale to an investor for a decedent's estate? Wow, fancy vocabulary.
Maybe, depending on the state, depending on the type of probate, it's a possibility.
Okay.
So something
very state
specific, and then state specific, and maybe that actual probate specific as well too.
Eric asks, are you working with any real estate investors in Bay Area, California? Not really sure what he's asking, but you have clients all over. Woohoo!
My favorite.
There you go. That's right. That's right. So, yeah, you're not coming to Fresno, guys. I got Fresno on lock.
Yeah. I don't do a ton of probates in California though, because a lot of times it's there's so much of a hassle and the investors aren't able to lock up their deals in the beginning. Like,
yeah, but there's another part of this. Let's not forget the part where a lot of my channel are building portfolios. They should be reaching out to you to get their estate set up, get their trust set up. I mean, some people on this don't have these things. Rylas is giving back. If you're in Arizona, California, reach out to the guy. See if you click. See if you fit. He can help you.
And I have helped several ORATers, so thank you. So I've had several great clients that have come from this channel. So I appreciate everyone.
Well, hopefully more will come from your Saturday deep dive. That's only fair. I know I requested this because I had 5 decedents in their 60s and older over the last year and a half. Okay. So good. Hopefully we got your questions answered, Chester. Victor, what do you recommend to California clients, investors with revocable trust who are investing in Florida? Oh, do you have any ideas there?
Yeah, well, just in any state you're in, you want to make sure you're state compliant. So something I see a lot, someone will have properties in another state registered in an LLC the other state. So basically you want to make sure if you have them in LLCs, you want to make sure that LLC is registered to do business in Florida, or it's either a Florida LLC.
Yeah. So
just make sure you're following local Florida laws. And then as a Californian, you just want to make sure you're going to avoid probate in both of those places. Make sure you have a plan. I like trust for, to hold all those things and
Mhm.
to pass it all.
Yeah. One of the things I would say is, and I've heard you answer this before, but if I'm wrong, please correct me. If you're going to do LLCs, don't do them on where you live. Make them where the asset is. Is that what you still recommend?
Yeah. And then I saw in another investor group, someone they opened an LLC. It was in Texas, and then she was
Mhm.
surprised that she got a $1,200 bill. But
It
but
can
I guess
happen.
Texas kind
Yeah.
of like California in that way,
Yeah.
where there's
California's $800, baby, no matter what.
yeah. So understand what you're getting into, and that's a cost of doing business in these states. So
Mhm.
I'd say consider that, if you're looking to own or invest in a state, you need to know all those things. You need to know if there's if there's fees at LLCs, and how to make sure you're state compliant in both places where you live and where you invest.
Is it a taxable event when transferring a deed to a trust? Can we deed property in our name of our revocable trust?
It's not a taxable event.
Not a
So,
taxable event. No.
so
In-
you're the
Into and
revocable,
out of, neither one is a taxable event.
correct.
Correct. Yeah.
Revocable trust is a disregarded entity for tax purposes.
Correct. Yeah.
So it's the same whether you own it or your trust owns it, not a taxable event.
Right. Looks like you got some new subscribers, so you're up from 750 already.
All right. Thanks, guys.
Yeah. Good morning, Wendy. How are you? This might be a dumb question, folks. There are no dumb questions. That's why these deep dives exist. If we put our LLC under a revocable trust along with our personal assets, and if some reason piercing the veil happens, then my personal assets will be at risk because they're under the same trust. Ooh, there's a sophisticated question.
Um, so the idea with an LLC is it limits the liability to the assets inside of that LLC if something happens.
Right.
I think what Wendy's trying to ask is if her assets are in trust.
Yeah, there's one big trust. It has the, like there's homes here in the LLC, and then the LLC is in the trust. And oh, by the way, they have their home and their bank accounts. Does that
Yeah, so
become a
just like
problem?
the answer to our last question was there's no the trust is disregarded for taxes. It's also the same in this level too. Whether you own it or your revocable trust owns it, it's the same. So you have no greater asset protection in just the revocable trust, but you're no worse off either. By adding things into a trust, you didn't put yourself into a situation that you weren't already in.
Got it. Oh, Kenny needs to go by. Somebody says port over will. Is that like a legal term? I don't know what that is.
Yeah, so that's the type of last will and testament that you do when you have a
Right.
trust. You have
No
a
idea.
clause in there that says if there's any assets still in my estate,
Mhm.
pour those over into my trust once I pass away.
Oh, okay. I did not know that.
So that's part of all of our estate planning packages. It's a way to make sure the trust gets funded, but it does not avoid probate if you rely on that. So you want to get things in there ahead of time.
Anna asks, is the strategy for liability protection, hiding trust owned by LLC, et cetera, different from strategy for avoiding probate or for probate avoidance? Sorry.
Yeah, so probate is kind of like the overall thing, right? Estate planning. I would describe my job or describe what I do the most simple way is helping people pass things to the next generation in the most
Correct.
efficient way.
Yeah.
So that means avoiding probate. That
Mhm.
means minimizing taxes. And that also means adding asset protection.
Right.
Meaning, how can we set up the next generation where they can have more protection?
Yeah.
There are ways to achieve asset protection yourself. How you hold assets. That's getting into the more advanced estate planning. You said hide. We would say shelter. We don't like to say hide.
Yeah, hide has negative
Shelter,
implications.
Shelter.
You're hiding assets.
Yeah,
That's
but not
awesome.
hide.
There you go. That's right. Clean up the vocabulary. Come on. Minimize, shelter. That's all. Lawyers, you got to love lawyers. They split hairs on vocabulary. I love it.
Yeah. So
So
right
man,
now, or go ahead.
I was going to go to the next question. If you have more to say, please.
Yeah, I was gonna say right now, the estate tax exemption, the federal exemption is about $12 million,
Oh,
meaning you don't pay any death tax or estate tax unless you have over 12 million. And a married couple, they can get two exemptions.
oh wow.
So
24.
24 million, really easy. Now, when I first started in this business, when I was in college, that exemption was around $1 million. So it was a lot more common that we were doing more sheltering, leveraging, more of those things for
Right.
the amounts over that exemption amount.
Yep.
But nowadays, you can have, estate planning has gotten a lot easier, I say, because, 25 million we can pass, no problem. So for most of America, that's
Yeah.
that's all I need.
Yeah. You're only licensed, I guess that's the right word, in Arizona and California, but would you consult on somebody in the other 48 states, or is that just like not a good idea?
No, I would just send you directly to someone there because I don't know the local laws there, and
Perfect.
you want to at least have some assets in that state.
As a real estate agent, what approach would you recommend to get listings? Same process mentioned before, go to the court, etc.
Yeah, I'd say same thing. Bring value. Show how you can be helpful. That's most of the mail I get and all the things, and everyone wanted to get listings, but
Yeah.
why are they going to list with you? Why? What value you bringing to them? They got three other realtors every day.
Yeah, you got to distinguish yourself. Again, like you said earlier, I just love the vernacular. Go through the front door, bring them business. Yeah.
Yep.
And
Another
then,
way too, I would say kind of it's probably like third on my list is go through the front door with a gift. Doesn't have to be anything fancy, like some candy, some baked goods.
yeah, I've
And
sent donuts. I've sent donuts every week until I got a meeting with one guy before that worked.
yeah, so good impression. Don't sit in their office and expect a meeting.
Yeah.
Don't don't pretend like you have a client, but you actually don't.
Yep.
Um, don't 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 call and act like you're my best friend. And
You sniff that out.
yeah. So I have my team, ask questions, what's going on. If you need help with the probate deal, they can start helping you right away. And that's our process. Like they're going to start
Right.
asking you like, yeah, who died, where's the property, and those things.
Right.
So yeah, don't hide the ball. And listings, I would say, same things I said before. And if you don't have any of those things, you can just go make an in-person impression. And it's kind of like cold calling. It's a numbers game. If you do it to enough and they have the need at that time, then they might try you out.
And then do me a favor, spell Mott Legal. People are trying to look it up.
MAATLEGAL.
Yep. MAAT. Yep. Mott Legal. Very cool.
Mott is the Egyptian goddess of law and order. So that's,
look at Rylas dropping knowledge. I like it.
so that's like my trade name.
Awesome. Would all beneficiaries have to sign off on approved sale of a house from an estate before going before a probate magistrate to request approval, or is it that probably a bit more state specific?
Maybe state specific. Let's see. So before a probate magistrate to request approval. So if there is a personal representative, one person that's in charge, usually
they make the decision. Yeah,
they can do it. They might have to get it approved by a court. Yeah. Now, sometimes I'll have a trustee or a personal representative, and there's a big family, and they're all close, and they want to have meetings over everything. And I'll caution them from the beginning, saying, I would not set that.
I would not do that. That sounds like a bad idea.
Yeah, because not only do you have all the siblings, it's usually someone's spouse whispering in their ear.
It jumps in. Yeah. We need that. We need that. Yeah.
Yeah. So, you figure out what's best, and, you can get some feedback, but, don't leave it to a vote and make people feel like they got to choose every part of the process.
So here's a question from Lorena that I'm going to kind of twist to help others as well. Let's say they're part of the ORAT family, which you are a part of, and they're not in Arizona or California. like in this case, Lorena wanted a reference to Colorado. How do you want them to ask those questions? Should they do that at Mott Legal? Should they do that in the Facebook group? Should they call your team? How do you want references to the other 48 states? How do you want to do that?
Yeah, either place, in Mott Legal or the ORAT group.
Yeah.
I have another private group for attorneys that I limit just to attorneys. And I would go from there. So if I had, so I could reach out in my private group and see if there's anyone in Colorado specifically that could help.
Yeah, let's try to
whatever
blow
state.
up Mott Legal, right? So MAAT Legal. If you want to ask for a reference in any of the other 48 states, because Rylas got Arizona and California on lock, put it there. Let's get his channel getting more views, more comments. Let's help him out. So very cool.
Yeah, thank you. And as you're networking with probate attorneys and estate planning attorneys, that's a good resource for them. You know, I'm a little different. I'm a lot different than attorneys in the sense that I'll actually share fees with real estate professionals. I disclose everything and I do it the right way. I wouldn't lead with that. That's going to make most attorneys nervous, but you can lead them to my private Mott Legal group. They just have to be an attorney to join. And I share with them how I do all of those things. Yeah. So I can help these attorneys be good resources for you as well in your community.
Yeah. And then Miss Wendy, our Facebook group, as you know, is One Rental at a Time Works. Rylas's Facebook group is for attorneys only. So you just have to go to Mott Legal on YouTube, not Facebook, on YouTube, MAAT.
I have a Facebook as well too. So if they want to ask questions there and
okay. What is that?
It's Mott Legal as well.
Oh, simple. Look at you. Look at you being consistent.
Yeah, I just have too many things I would say though. But yeah, Mott Legal is where it's turned into where I help real estate investors, and I do the most videos about real estate as well as estate planning and probate and law topics.
Very, very cool. Well, Rylas, we've exhausted all the questions. I want to thank you for this deep dive on Saturday. It obviously was very valuable to me and the group. It will also be posted on YouTube tomorrow at 9 a.m. So hopefully you see a lot more subscribers on your channel, folks. If you're still listening to this on Sunday, do Rylas a favor, go to Mott Legal, MAAT Legal. Give him some love, subscribe. We've got to get him over 1,000. Rylas, thank you very much. Have a great weekend.
Thank you. We'll see you guys.
You got it. Bye.